Okay, hello everyone. Thanks very much for attending this first COVID-19 related panel that's being organised in collaboration between the Sheffield Legal Hackers and Anson Evaluate. So I just want to quickly introduce a little bit about the hackers movement before I pass over to Louise Glover, who's going to be chairing the event, and Louise will do a bit of an intro introducing all the speakers. So just very quickly, for those of you who don't know, Legal Hackers is a global movement that was started in Brooklyn in 2012. Effectively, it's a movement that tries to bring together lawyers and technologists, but really is more expansive than that. And I think that was the initial idea, but it's expanded a lot since that time. So there are chapters all over the world. The Sheffield chapter has been going for about 2 years now. I'm one of the committee, and there's a committee of 5 of us at the moment. So we've been kind of organising events for the last 2 years on various different themes, usually getting in external speakers. This is our first official virtual event. We did have an online quiz, which some of you may have attended a couple of months ago, but this is the first panel event, online panel event that we've run. We hope to be able to this to be a first in a series of panel events, so we will keep you posted on those. So they hopefully will be COVID-19 themed. And we will keep you posted on the usual channels about those. So that's just a little bit about Sheffield Legal Hackers. So please do keep looking out for us. And I'll pass you over to Louise now to introduce the panel.
Lovely, thank you, Gareth. So welcome everybody to the first event in the Sheffield Legal Hackers online panel series to discuss contract tracing apps and the possible implications for privacy, law and society. I'd like to thank Sheffield Legal Hackers, especially Matt and my colleague Gareth Bramley, who you just heard from, for organising this event, and also to Heather Anson for not only of Anson Evaluate for not only speaking but also hosting with the GoToWebinar technology. Also, thank you to London Legal Hackers and the Global Tech North community. So thank you all of you, and thank you to all of you for joining us. My name is Louise Glover. I'm Director of Civic Engagement at the School of Law at the University of Sheffield. So our question tonight could not be more important concerning public health in a pandemic in which up to 22nd of May, there's been nearly 44,000 deaths involving coronavirus registered in England and Wales alone, rising to 50,000 deaths across the whole of the UK. We are, in some shape or form, in a national lockdown in which our economy has been described as going into free fall. And the Bank of England has forecast the sharpest recession on record. Unprecedented financial support has been offered by the government to attempt to avert this. Lockdown has had a high personal cost, with family members only able to make a final phone call to loved ones, and in some cases attending virtual funerals. There are warnings of a looming mental health crisis amongst the public and key workers alike. This is in one of the world's richest and most advanced economies. With new cases running above 100,000 a day worldwide, the G20 has been urged today to act to mitigate the catastrophic effects on the world's poorest peoples. In the absence of a vaccine, hope is being put on track and trace, which appears to have been used successfully in low-impact countries such as South Korea. The approach in the UK is to be by a blended use of manual methods, which we are told are now in place, and a smartphone app developed by NHS App. The hope is that by pinpointing more precisely individuals who should be in quarantine, the government will be able safely to ease the lockdown restrictions for the rest of the country. So the stakes really could not be higher. Track and trace raises issues of public trust, which technology to use, whether personal data should be held centrally or on each individual's smartphone, its reliability and effectiveness, and of course its impact on privacy, as well as its lawfulness. As some have warned, governments rarely give up powers once granted. So our question tonight is, can the public have confidence in the NHS app? To discuss this, we're really grateful to have the expertise from a range of viewpoints across the technological and legal sector. We have Dr. Chris Culnane, who's an independent security and privacy consultant and visiting lecturer at the University of Surrey, and I believe recently back from the University of Melbourne. Dr. Greg Paul, research engineer in electronic and electrical engineering from the University of Strathclyde. Dr. Orla Linsky, associate professor of law at LSE Law. Dr. Mark Pokowitz, from the Legal Innovation Centre at Ulster University. And Dr. Heather Anson of Anson Evaluate and Digital Law UK. So our format for this evening is that each speaker has been asked to speak for roughly 5 to 7 minutes on their area of expertise. Please raise any questions that you would like to using the controls to the right of your screen. I hope they are on the right of all of your screens. They are on mine. You will see that there is a box marked questions. Please use this one rather than the box marked chat to give your name and your question. And you can raise a question at any point throughout the evening. We will do questions at the end, but please, if a question occurs to you while someone is speaking, please do raise it at that point. Once all of our guests have spoken, I'll invite them all back on to answer your questions. So we're going to go first, if we may, to Dr. Chris Culnane. So if I could ask our other panelists to please step back from the stage by muting your audio and muting your camera, and we'll pass over to Chris. Thank you.
Thank you, Louise. So to give a bit of background, myself and a colleague, Vanessa Teague, when NHS App released the app, we took a look at it from a security point of view and conducted what we would term as a static security analysis. That involved going through the information that had been published on the National Cyber Security Centre in terms of their white paper and the blog post from Ian Levy, and then going through the code and seeing how well it matched up to that, and if there were any other concerns that we had regards to its implementation and its design. We then published the results of that, and the first thing I would say is that the NCSC were very responsive when we contacted them with those results prior to publication. They confirmed the ones that we'd found. They also acknowledged that they'd already known about some of them or were in the process of fixing those, in particular about encrypting the data on the phone as well as before it gets uploaded. We did highlight a new potential vulnerability in how it was triggering what's known as the 8-second distance measures, which is one of the features of the app. But all in all, they did what I would say is a good job from a technical point of view in addressing the concerns and engaging with us, making the source code open, and then actually publishing a public response. So from a purely technical point of view, I'm confident that NCSC and NHSX will be able to address the technical issues we raised in our concerns in our report. More broadly, though, the concerns I primarily have are around the policy decisions. So the first one is obviously the one which we've already slightly touched on, is the difference between a centralized and a decentralized system. The difference primarily in terms of the data is that who gets to do the mapping. So in a centralized system, the central authority will conduct that mapping, and therefore it's the central authority who ends up learning that information in the long term. In a decentralized system, then that mapping should be being done on the phone. And as long as it's done in a sensible and secure way, then the information shouldn't ever be, no one should be able to learn anything they didn't already know. Now, the UK's gone down the centralized approach, as has Australia, as has Singapore. Germany is looking at a decentralized approach, and there's various different ways in terms of actually implementing that someone can do. But in general, that's the difference is to basically who learns what. So as soon as you take a centralized route, then you really need to make sure that the privacy and the security around that is much, much stronger, because you now have a central authority who's collecting and having access to this data. So in that sense, we would still have some concerns around some of the design decisions. Probably the most important one is what's called the broadcast value. So this is your kind of unique ID that your phone is broadcasting, which other devices can pick up and record having been in contact with you. In the UK version of the app, this runs for 24 hours. So your ID will stay the same over a 24-hour period, and then it will be renewed. Now, the concern we have around that is that that is now constantly being broadcast, and anyone else who's listening to it can potentially track that device. So this isn't uncommon from a technical point of view. This already can happen in what's known as MAC addresses in Bluetooth. So the identifying, a bit like your IP address, can be tracked as you move around, and it's used for location tracking in stores and in large venues which may be interested in how people are moving around. Now, that ID is supposed to rotate every 15 minutes at maximum, but sometimes less than that. If you now have a 24-hour broadcast value, you're not only undermining the security built into the standard, but you're now making it potentially someone can be tracked when they return to the same location. Other issues that we had concerns around are the fact that there's no guarantee the data will be deleted from the central authority at the end of the whole process. If you compare that to Australia, they have put in place legislation that says that data has to be deleted at the end. We'd like to see similar guarantees made in the UK. Furthermore, we'd like to see protections about switching on Bluetooth. Bluetooth is primarily used as a tracking technology. We might, as consumers, think of it as being a way to connect to our car or our headphones or smartwatch, but in terms of commercial data collection, it's used for location tracking. And anyone who's looked at the app will notice that if you want to enable Bluetooth and your app needs to access it, then you also have to give permission for location information because it's considered to be synonymous with each other. If you have access to Bluetooth, then you can work out where someone is. Now, the app does not try and work out someone's location, but the issue it has is that if you enable Bluetooth on your phone, then all of the other apps which previously maybe couldn't do that now are able to start determining your location. So in terms of your privacy position, you've got a slightly worse position than before. And given that we're asking consumers to give up on their privacy, it seems reasonable that those big companies, maybe during the crisis, are told you can't use Bluetooth in order to do this type of profiling and this kind of tracking. So overall, in kind of a summary from the technical side of things, the response has been good, but from the policy side of things and some of the design things, they still remain outstanding. And if the purpose of the app is to get a large uptake, then it's going to be essential to build trust. And so we would like to see far more transparency and discourse around those policy decisions, which are in some ways more important. And what's happening at the moment is that some of those technical aspects and the good side of things in terms of actually being responsive to that are being undermined by the broader policy issues. So we'd like to see a number of changes. We've put them into the report. So far, the technical issues have been addressed, but the policy ones remain outstanding. So I'll leave it at that point, and then hand over to whoever's next.
Hello, can everyone hear me okay? Great, apologies for that. I just had a technical problem for a moment there. Thank you very much, Chris. That was really interesting, and interesting that you've already raised many of these issues and had some kind of comeback on them. Next, can we go to Dr. Greg Paul, who is a research engineer in electrical and electronic engineering from the University of Strathclyde. Greg, would be delighted to have your take on this, please. Thank you.
Sure. So I think Chris gave a good introduction and overview there. I think it's useful to start back at the start again and just rewind to how we got to where we are with contact tracing briefly, because there's a lot of confusion, and I think one thing that's making it more complicated is a lot of people are talking about the contact tracing approach in general. When they are discussing that when they actually think they're talking about the app and vice versa, and it can get quite confusing. Contact tracing as a system is not new. It's been used since, probably the 1300s in the Middle Ages, when people used to put crosses on doors in the plague. So the idea of contact tracing isn't a completely new concept. In terms of the technology here, what we're looking at, I think we need to consider this in the context. When we talk about privacy, we should look for what we can get and what we can achieve, but at the same time we also need to look at what the alternative is. So in terms of contact tracing, ordinarily what we'd be talking about is someone phones you up, says you've tested positive for COVID, or we think you're going to test positive for COVID because you've been exposed to someone that we believe to be infected, and therefore what we would like you to do is tell us who you've been in contact with over the last, say, 7 days or 10 days or whatever. So if you can give us some names and if you can give us phone numbers and email addresses, then we will go and contact these people and alert them and take whatever measures might be needed. That's the traditional alternative to contact tracing. You know, that's the traditional way to do contact tracing. Now, in terms of the question about decentralized or centralized, there's, you know, decentralized from a technical perspective is a really good way to do it. It's really nice and elegant and neat, but it's not necessarily cut and dry that it is the right way to go and it does the best thing. So what I mean by that, for example, is if we look at the decentralized approach to contact tracing, what you effectively do is create a list of all these 10-minutely or 1-hourly identifiers, and you get a list of the ones that are infected, and then you have to send that and make that available to everybody's phone to go and retrieve once a day, twice a day, and then check the list of people or devices they've been near and see if any of them show up as having been on that list. And if they are, then you can take whatever action on the device by saying, well, how many minutes do you think I was exposed for? Were they strong Bluetooth signals, etc.? It's a bit rough and ready, but you can sort of come up with an idea and say, okay, you probably were in contact with someone that was positive. Well, you should probably self-isolate. And that's the approach to the decentralized system. The big downside of this, I think we need to note, is from a privacy perspective, it creates the kind of modern day equivalent of a leper list. So you're creating a list of not people's names, but of these random identifiers of people who've been infected. And there are a few approaches you can use if you want to look at who has been, you know, exposed. For example, if you've been in contact with someone privately and your phones have been together, you could work out fairly easily from the time and the timing of these Bluetooth pings, which identifiers were theirs, and then look and see if they appear on this infected list in the future. Does anyone care? I don't know. But from the privacy perspective, that's something worth noting. In a centralized approach, it's a little bit different in that you do not have to actually transmit around the list of people or their identifiers that have been infected. Instead, what they do is they transmit the list of people they came into contact with. Now, there's clearly a difference here, and there are going to be privacy implications when you actually communicate that list of devices you've been in contact with, because that forms a social graph. But from a privacy perspective, I think it is important that we look at the difference here, because a system like this can only work if it's effective and people are willing to use it. And these are going to be really important. In terms of making it effective, I think we need to look at the epidemiology, which I'll come on to in a second or two. But in addition to that, I think we also need to keep in mind for people to be willing to use it, if they feel that their privacy will be reduced, they might not do it. Now, in a decentralized system, with the creation of that list, effectively the privacy is biased towards those who are not infected, because when you're infected, a big list of your identifiers ends up being public. Now, do people care about this? Is this something that bothers them because people might be willing to share that? I don't know. That's an interesting discussion to have. But the centralized approach slightly levels that out in some ways, because it sort of averages the privacy across all users, because a user who has been infected doesn't actually end up having their identifier scattered everywhere for others to see. Now, in contrast, though, they do lose a little bit of privacy in terms of the fact that there exists mappings between identifiers, some of which might be theirs. And the model of security that NCSC and NHS have looked at is to say, well, we're going to level this out, and the reality will be that hopefully you won't be able to determine who anyone is because there's no side information that would help you de-anonymize someone. Just to jump on to the last point very quickly about epidemiology, I think we're dealing with a disease here we do not fully understand, but it does seem to be that the mean and median time to get symptoms is about 5 days. And this can be quite challenging because people appear to get the most infectious in the 2 days prior. One of the things that I think we do need to touch on and remember is that when we are trying to build a system that works, we need to make sure that we're acting quickly enough. So if somebody gets infected, if we have to wait for them to get a test, which is generally the approach for the decentralized system, to stop people just randomly going around saying, I'm infected. If you need to wait for someone to get a test, there is a downside here, and it might be too late, because by the time you get the test results through, chances are people they've been in contact with are walking around on about the first or second day of their most infectious time, spreading the disease before they know about it. In a centralized system, there are ways that you can actually measure the likelihood that someone does have COVID, and therefore determine that if they report symptoms, so reporting symptoms here, rather than a test result, that actually it might be possible to alert people they were exposed to in advance of getting a test done, and actually alert people to self-isolate earlier on because you think they have actually been at significant risk, but also then to alleviate false positives and actually tell people earlier, look, you don't need to self-isolate because 20 people were exposed at the time you were. It's now 5 days in and none of them have symptoms. You're good to go. Out you go. So there's interesting approaches here. I think I would just emphasize the importance, firstly, privacy in this is really important, but that we do need to make sure it's effective and it's going to work and that people will be willing to use it. And at that, I think I'll finish up there and hand on to the next speaker.
Lovely, thank you very much indeed, Greg. I think it's interesting with that there's a lot more nuance perhaps in the distinctions between the systems and the pros and cons than some of what's widely available would suggest. So thank you very much for bringing some of that out. Next, can we go to Dr. Mark Pokowitz, Director of the Legal Innovation Centre at Ulster University, please.
Hi there. Can everybody hear me okay? Great. Well, thank you so much for having me. And thank you, Greg and Chris. This has been fascinating and I've learned a lot too. So I'll kind of put on my civil libertarian hat and look at this from an American lawyer's perspective, which is to say that I clearly understand that COVID-19 is a serious, serious issue. And it seems that we've decided collectively that using contact tracing applications may be a way to help us combat that. And I think that's very important. But one of the things we kept hearing people raise is this issue of privacy. So the immediate things that spring to mind are certain relationships that are held sacrosanct. There are certain privileged relationships we certainly have in the States between lawyers and their clients, between reporters and their sources, between priests and their penitents, and all kinds of other areas where you could certainly understand a concern with the ability to potentially map out relationships and map out what's happening with other people. So if you have somebody who is a reporter meeting with a confidential source about certain kinds of issues, and you had the potentially a centralized government authority getting the ability to then map out those networks, that could be seriously problematic. Coming from policy background in Washington, where I worked on some issues that touched and concerned national security, there were certainly things that I didn't put in my diary. There are certainly people who wouldn't email me using open systems. So the idea that we would potentially be taking all of these devices that we have with us and putting them in a situation where not only could we potentially be tracked geolocationally depending on the jurisdiction and the application they use, but we'd actually be exchanging tokens perhaps with the people we come into contact with could be very troubling. So I want to kind of think around the issues and the potentiality for surveillance. Now, I laud the governments that are taking an open approach and looking at these things from an open source perspective. It's great when experts and engineers can look at the code and interrogate it and see what the issues are. But from a policy perspective, one of the things we've heard is the concern as to how the data is being stored, how it will be deleted, what deletion actually means. And I'm sure that we'll get back to this, but from what I understand, a lot of software engineers like to hold certain data for testing purposes. There can be potential value in looking at this data from an epidemiological perspective long beyond the utility of the application for the current crisis. So I have very, very big concerns when it comes to how these applications, how these tools can be used for things like biometric or digital surveillance. There has been suggestions, for instance, in the United States, which has some unrest at the moment, to use contact tracing to map out networks of looters in the protests that are happening around the world. You could certainly imagine a situation where a regime that is somewhat oppressive not only would require people to download the application, but impose crimes or sanctions for not using it, and even use it to try to map out networks of political dissidents. To me, there are also additional concerns with respect to the requirement that people use the applications who avail of certain public services. You could easily see an area where licensed professionals, perhaps even lawyers, could be required to download or use the application in some jurisdictions. Healthcare workers be required to download or use the app. School children be required to download and use the application. So while some of these comments speak to the more general concerns that I have, I'm sure that we're going to get into some of these specific issues, not only within the UK, but with the European Union in general. But from a global perspective, it is a difficult balance, to my mind, to strike between the urgent need to figure out a means to wrap our heads around this public health crisis and look towards solutions that could help us curtail the epidemic, while keeping in mind that there are certain things that to me seem somewhat more perfidious than the fact that we do have these devices with us, rather, that can track us generally. Because to me, what becomes more problematic is this idea of keeping tabs on all of our relationships. Now, some of you listening might say, Mark, you're being ridiculous. We use things like Gmail, and we use things maybe like Hotmail or Outlook, or Outlook.com, that is, or what have you. And so there's certainly ways that we can map these things. But generally speaking, when, to my mind, this data is more distributed and not as centralized, even though some of these things in and of themselves can be somewhat concerning, to me, the level of concern escalates significantly when it comes to the idea that a centralized authority could be collecting all this information, and it's not particularly clear to us how it could potentially be used and or abused. And I'll kind of wrap up by saying that one of the big concerns we had in the United States after the Edward Snowden revelations had to do with something called the doctrine of parallel construction. This is when a government authority finds out about something and they cannot reveal the sources and methods, so they reverse engineer a means by which to create a law enforcement investigation. So for instance, you would hear examples of a police officer deciding to get a cup of coffee at 4 o'clock in the morning toward the end of a shift, which in and of itself is strange at that time of day, but going to an area of New York City completely far away from where his house is. And so it just seems incredibly peculiar that he would just happen to witness something that warranted further investigation, when in reality, there's no reason why the officer should have been there in the first instance. So we saw a lot of instances like that where it seemed evident that some of the intelligence forces inside the United States government were giving intelligence they'd collected potentially illegally to local law enforcement who were reverse engineering. And I know that might not be a concern here. It certainly is a big concern for a lot of people, but I get very, very wary when we seem to be in a situation where we're presented with a choice between health and safety or privacy. So I'll leave it at that, and hopefully people will come back to me with questions.
Great, thank you very much, Mark. Yes, I've definitely seen lots of comments on Twitter. I imagine we all have, that no one in their right mind in the States at the moment would be downloading a contact tracing app. And whilst we don't have quite the same issues at the moment, there has been concern at an earlier stage of the process when the rules first came in about police overreach, and to the extent that the Derbyshire police drone certainly became a bit of a talking point on Twitter for its vigilance. Thank you very much indeed. Next, can we go to Dr. Orla Linsky, please, who I think will be able to give us a specifically EU perspective on this. So to give us the view from the other side of the pond. Orla is Associate Professor of Law at LSE Law. Thank you, Orla.
Great. Thanks, Louise, and hopefully this will follow on from what the previous speakers have already kind of brought to our attention. So, as we just heard, my perspective on this is primarily coming from an EU and European fundamental rights perspective, as those rights exist in the law in England and Wales. So here I'm talking about rights such as the right to respect for private life that you have in the European Convention of Human Rights, which is not an EU instrument, but also then an EU Charter of Fundamental Rights, which not only sets out a right to privacy, but also a right to data protection. And I'll explain why I'm kind of highlighting that difference at the outset in a few minutes. But in essence, following on from what Mark was just saying, when you start to approach the issue of contact tracing from a privacy law perspective, the first thing to note is that there does not need to be a kind of a full trade-off between the right to life and health on the one hand and the right to respect for privacy and data protection on the other. What we have seen through kind of consistent case law over decades is that privacy, data protection will give way or will cede way in order to achieve other legitimate objectives. So instead, what privacy seeks to do here is to impose safeguards or to ring fence the extent to which it gives way, to make sure that it doesn't give way more than is necessary in order to achieve those particular objectives. And so we know here that in the context of contact tracing, the objective that we're trying to achieve is one of public health. And so in order to assess whether or not the app is suitable to achieve that, well, we've, I think, 3 questions. Is the app suitable to facilitate public health objectives? Is it necessary to achieve public health objectives? And then does it go beyond what is necessary in order to achieve those objectives? And this is where I think the NHS app as proposed starts to fall on kind of unfirm ground. So when you look at contact tracing, even generally, although manual contact tracing is a kind of a tried and tested method, I would say the jury is still very much out on the effectiveness of digital contact tracing via apps. And so if you look at something like the Singapore Trace Together app, and Singapore is often kind of held out as a country here that has done incredibly well at stemming the spread of the virus. The director of the Singapore Trace Together app has himself indicated that the app shouldn't be looked at as a panacea. It was only downloaded by 22% of the population in Singapore, and he says contact tracing is kind of by its definition, by its thrust, a manual exercise. So, first thing is that the app should never be looked at as a substitute for manual contact tracing. And that kind of goes to this question of its effectiveness. But let's say we assume that the app could be effective, because we also don't have conclusive empirical evidence that it's not. So, you go with the benefit of the doubt that the app could be effective. This still raises questions about the design of the app and the way in which it's been implemented. Is it going beyond what is necessary in order to achieve its stated purpose? And so here, Greg has already alluded to the big debate about, whether or not a centralized app is more appropriate than a decentralized app. And here, I must admit I hadn't kind of considered or given ample thought to the leper list issue. I'd be curious to know how precisely, that list, I guess, will be available to all those who use the app, but how they would kind of re-identify the individual based on that list. But, I would completely admit that must be technically feasible, that it is in essence a list of personal data. But, rather, we know the risks of centralization, and Mark has just alluded to them. A risk of function creep, I think, being the primary one, that this centralized register of data will be or may be used again for purposes that are not those for which the data were originally collected. And so here, when you look at the safeguards that exist in data protection law, I think a few are particularly relevant, and we haven't necessarily seen the NHS in its data protection impact assessment elaborate on how it plans to comply with these principles. So the first is data minimization. And so that's the idea that you collect the minimum amount of data necessary for your stated purposes. So, as we heard, it might be that additional data is necessary for epidemiological purposes, but that's nowhere kind of set out in the NHS impact assessment for the app. So we've heard, for instance, from Matthew Gould that in the future, additional functionality will be added to the app around location data, for instance. But again, it's not kind of indicated why that data is necessary in combination with the other data that's being collected by the app. In particular, given that the risk of including location data with the data collected by the app leads to a very clear one of creating a social graph without the consent of others who have chosen not to upload location data to the app. Another issue is one of storage limitation. So at the moment, if you look at the impact assessment for the NHS app, it does not state the period of time for which the data will be retained. And it simply says it's not possible to do so at the moment. However, this gives rise to at least speculation that the data will be stored indefinitely or for a disproportionate amount of time. And you only need to look at the impact assessment for manual contact tracing to see that the proposal there is that the data of infected people is retained for 20 years and the personal data of their contacts is retained for 5 years. And that could be in no way necessary to deal with the current crisis, the current pandemic. So, and if that data is to be used for future research purposes, then it could be anonymized, for instance, but there's no reference to that. So we have complete silence on the issue of kind of storage limitation. And we also have a lot of ambiguity on the issue of purpose limitation. What use will be, what purposes will this data be used for? How can we guarantee that we won't have a kind of a function creep or a purpose creep with that data? And here again, for instance, it said that the data could be used for future research purposes. It doesn't limit those research purposes to COVID. It doesn't limit that research to publicly funded bodies, for instance. So it could be private bodies that are gaining access to this data. So it leaves a lot of scope for, well, a lot of ambiguity in essence around future uses of the data. So I would say these are clear areas where the data protection principles haven't been complied with. And then from a very procedural perspective, the Information Commissioner in the UK, the regulator, has discussed the app with NHS X, but wasn't kind of given the opportunity through a kind of a prior formal consultation to provide feedback on the app. And again, I think that's an illegal, that's a legal irregularity. I think there was an obligation here to provide the data protection impact assessment to the ICO before the app is rolled out. And so, you know, what would I like to see change? Well, in essence, I would like to see legislation in place that would put in place cast iron guarantees that things like purpose limitation, storage limitation, data minimization are going to be respected by this app. But also, going to the points that Mark just made, I would like to see guarantees in place that go beyond data protection law and go to kind of broader civil liberties and issues here around non-compulsion. So one final point to make is that the app is voluntary, or so we're told. And so the legal basis, the legal justification from a data protection perspective that's been relied on for the app is consent. This can be contrasted with manual contact tracing, where the legal justification is public health. And so I think this is important that we're relying on consent in this context for two reasons. First of all, in future, it might be open to the government to argue that if you have consented to the app, there is no privacy violation. And once we hit the end of the withdrawal agreement, the transition period rather, with the EU, then the right to data protection, which we currently avail of or currently benefit from, will no longer exist as it does in UK law. And so we might lose one of the key avenues to challenge this app on the grounds of privacy. And I can clarify that point later on if helpful. But the second issue, I think, is that this doesn't deal with private sector compulsion. Even if the app is in principle voluntary, what happens if my employer won't let me into work unless I produce the app? As we see in Australia, what happens if you're not able to book a table in a restaurant unless you produce the app? This raises significant issues around digital exclusion. We know that 22% of people in the UK don't have a phone, don't have a smartphone that might even be able to host this app, and quite a lot of people have smartphones that are not technically updated in a way that would allow them to host the app. And so, in this sense, there's a risk that the app becomes de facto compulsory. And this is why Lillian Edwards and many other legal academics, myself included, had proposed a coronavirus safeguards bill that would apply to the app, but also additional proposals that are being put on the table around things like immunity certificates, because we think that additional legal guarantee is needed in order to facilitate trust in the app as it stands. So that's all I'll say for the moment.
Great, thank you. Thank you very much, Orla. Yes, some really interesting points there about the interplay between the public sector and the private sector in relation to that, I think. Finally, can we come to Dr. Heather Anson from Anson Evaluate and Digital Law UK, who's going to wrap up for us on a number of points. Thank you.
Yeah, I've got sort of a storm of different qualifications here. I am also a US qualified lawyer, ran a practice in the States for quite a while, been a visiting professor on different topics. I've got a background in philosophy and medicine, so I covered a lot of stuff. But one of the things that I do lecture a lot in European law schools is on this sort of interplay between security and privacy, and sometimes how they're conflated. and also how our intentions in creating certain laws create unintended consequences. And the first speaker came up, I think, I can't remember, I didn't make in my notes who it was exactly that said it, but was talking about Bluetooth and the fact that if we need to have Bluetooth on it, does that mean automatically Bluetooth is then being used for our other apps, when from a security standpoint, we don't want that. So we have the unintended consequences of it. If we have an app using that technology, then it's forcing you to give that permission to other apps potentially. And even if it doesn't automatically do that, you may not have the technological understanding of how to switch off permissions. So are you able to do that? We also have the unintended consequences of the decentralized system. And there's an example of this in how South Korea has been handling the app, and they've done a contact tracing thing that essentially does push notices to people's phones in an area where there has been a person who is diagnosed with COVID-19. They don't give any information about the person in terms of their gender, their age, or anything like that, but it does say, if you've been to this restaurant in this time period, this store during this time period, or this place during this time period, then you'll want to maybe self-isolate or be tested because you've come into contact with someone who's been tested positive. What's happened with that is private individuals, and I think this is what was referred to as the leper list. They've gone on to Reddit and Twitter and other places to sort of reverse engineer those locations and have been able to successfully find out who some of these people are, so that they are able to then publicly on the internet shame those people, like, why were you going into that store without a mask? You were feeling ill that day. Your coworker said you were feeling ill that day. Why did you go into work? So the unintended consequences of an app that in and of itself did not have any privacy issues in it created privacy issues because the outside world was able to figure out, sort of take that information and put the puzzle together, and sometimes rightly and sometimes wrongly find out who that person is. So this is something to think about when we're talking about the unintended consequences. I have a slightly different feel about privacy than maybe my other American colleague. Maybe I'm not so libertarian, I don't know, but I think we have to take a balance, and this is an important thing to think of. I'm not dismissing our need for privacy, I'm not dismissing our need for protection, but there is a balance between looking for the right mix of a successful track and trace app that protects the public and the right to privacy, understanding that the history of the right to privacy, the way we view it now, particularly with the internet and smartphones, has grown tremendously. Our public understanding and feeling to what the right is has become much stronger. Whereas from my perspective, I always tell people that if the CIA doesn't have a file on me, they're not doing their job. And that seems like a fun thing to say, but if we think about it, those of us who are in the privileged position of being able to talk about these theoretically and say, I don't want my information shared and I don't think it should be shared, we are generally, academics, lawyers, scientists, who are not going to be likely the people who are going to be doing anything wrong in a criminal system. So we don't really internalize that understanding that it might be important to catch some people who are not doing anything wrong in a sweep, so that we get those people who are. And in my case, I can say when I was a student at university, I started something called the Wartime Student Unification Committee. That put me on a radar. When I was running my law firm, I had clients all over the world, including in the Middle East during the Gulf Wars, during the Second Gulf War, and I've traveled now for my clients in areas. I was in the Ukraine right at the same time the election was going on, talking to law students about the rule of law. there are a lot of things going on that some government should be paying attention to. And I understand that they should to some extent. And I don't feel like we are understanding that if for some reason one day, let's say I cracked and I went out and did something, why the reaction of the public would be, how did you not know this about this person? How did you not know that this was a risk of them? Because you should have known. So we have this two-sided reaction to things. One is we want our privacy and we shouldn't be looking at this and we shouldn't be giving the government all this and there isn't a good reason. And why didn't the government know this ahead of time? Why didn't they do something about that? And you see those coming together, and we need to understand that that is something that's happening all the time. There are ways that the community can be a bit activist in responding to some of these misappropriations of online data. For example, in the US, which is a great example, there were some protests many years ago. It seems like ages ago now. It was a I think even a pre-Trump era protest over the pipelines across Native American lands, and people were going and protesting, and the local authorities were using Facebook check-ins at that location to identify people who were protesting and there, and trying to arrest protesters who were there unlawfully, as they said. So there was a movement on Facebook to check in at that place even when you weren't there. And loads of people on my feed who all over the world checking in at this place, and they weren't there. And that was their way of almost countering that use of people's private data, saying, okay, we're just going to overwhelm you with false information. So there are sometimes ways of doing that. There was also a really good point on the effectiveness of this app in terms of people who may or may not have access to the technology. And I'm in with a vulnerable category in terms of health because of a kidney disorder. So for me, I have a vested interest in knowing this, but I'm also au fait to technology. So I understand maybe some of the ways that I can limit an app and do that. But I have a lot of elderly friends and relatives who don't have that. I also have several pro bono clients who are homeless or sheltered homeless, who don't have these apps, but who are very vulnerable from that standpoint. And how are we making sure that those are covered? We've had a lot of outbreak in care homes, and those people aren't going to necessarily be able to do this app. So those are the kind of issues I think we should be thinking about as well. And just before I pass it back to everyone so we can go to questions, I'd like to let everyone know that the full transcript, the full PDF of that NHS X COVID-19 response opinion is in the handout. So there should be like a thing on your screen that says you can download a handout. There are two of them. There's that, and also links to articles or reports or papers that the other panelists have written, which are very useful and helpful. So with that rambling response from me, I'll hand it back to Louise so we can have some questions.
Thank you very much, Heather. And I think you've made the point very clearly there that the app can't do everything, that the manual system that I think Greg mentioned at the beginning is going to need to go in tandem with it, isn't it? So if I could thank you very much to all of our panelists. If I could invite you all, please, to come back on stage, as it were, by putting back on your mics and your cameras, and we will have some questions. So we've got a number of questions from all the listeners, so thank you very much for those. If you have got a question still, please do post it up there. The format that we'll follow is I'm going to put the question to the panel. You just need to bear with me because I can see, unless you can teach me a workaround, Heather, I can see one line of the question at a time. So it will sound a bit like I'm reading it off an auto cue. So this is a question for everybody. Sorry?
If you've been able to pull it out, then it may open up for you a bit bigger.
Yeah, no, it seems to be the same whether it's in or out, but I'll just scroll through it.
Okay.
So a question for everyone. So in terms of confidentiality, not effectiveness, how does the app compare with the manual approach where you phone the government and tell everyone you think you've met in the last 10 days, if I understand how that works correctly, with the 21,000 human employees that will follow this up? Yeah, so that's a question there from Duncan Eady. Thank you. I'd like to start with that. Greg, I think you started by talking about the two systems, so can I come to you first?
Sure. So yeah, I think you're right, and this is the question that we need to we need to think about. We need to look at this in context. With contact tracers working from home, clearly there's going to be some confidentiality challenges there in terms of, you know, what's accessible to them over the web, what's accessible to their own computers that aren't necessarily locked down as much as we'd like under normal circumstances. Equally, we trade that off with the fact that we can't stuff them all into a big call center elbow to elbow, because then we'll actually just end up creating more spread. So I think we have to balance that off. But I think this is, to me, I'll explain the process. The way it works is if someone tests positive, then they would receive a phone call, you know, along with their test result. They will get a call from a contact tracer and they'll say, you know, you've tested positive, you had symptoms, you got tested positive. So could you tell us a list of who you've been in, I think it's within 2 meters of, for a period of 15 minutes or more when you weren't wearing PPE, which is basically everyone that's not a doctor or a nurse. So at that point, then you sort of give them a list of the people and they want, you know, names and phone numbers, and then they will go away and make contact with those people and then alert them. Now, they will not tell those people who you are, but they will be able to tell them that they've potentially been exposed and you should stay at home and you should call up NHS 24 or use this use this website to book a test, get yourself tested, and so on and so forth. So that's the way that the process works for the traditional one. Now, clearly there's confidentiality implications around telling someone that information and also of storing it, because it's not anonymized, it's the exact opposite. It is completely identifiable. So from that perspective, yes, you are giving away a lot of information and it will be retained for some period, and that's where the legal angles around what protections are in place need to be really looked at carefully.
Yes, I think that's all I was saying, that for people who are symptomatic, it's going to be kept for 20 years, and for those who are not, it's going to be kept for 5 years, which seems an extraordinarily long period of time. Chris, can I come to you next, please?
Yes, so I think one of the big differences is the granularity and the resolution of the information that the app is currently going to collect. So one, it's not, ideally it would only collect people who are within 2 meters, but the way that Bluetooth works, you can't guarantee that. So it's going to collect people who are further out than 2 meters as well. And then there will be some modeling that's done centrally to try and kind of threshold that between people they think are within 2 meters and people they can ignore. So you've got a more detailed social graph being built. You don't have any names attached to it, but it is definitely a more detailed social graph. One of the unusual things about the NHS X approach is that they monitor that interaction every 8 seconds. So if you're within 2 meters of someone, they are monitoring how far away they believe you are every 8 seconds and store that record. So what that creates is a far more detailed picture of that interaction, because they will be able to determine roughly how far away you were to begin with. Did you get closer towards the end? Did you get further apart? They know how long that interaction lasted and what time it was at. So you start to reveal what we would term lifestyle attributes to some extent, in that you can start to determine how long that person is. Did they potentially hug when they got closer together towards the end? Were they sat much closer together during that whole interaction? So in that respect, you've got a lot more data being collected. And the other thing you don't have, which has been kind of raised in some alternative apps, is you don't have the ability to not give a particular piece of information. So in the standard contact tracing, you don't have to necessarily give all the data. You could not give the one when you're speaking to your lawyer. And in the case of the app, there should be a way in which you can exclude certain parts. You may have to say that you've excluded them so they know they don't have a complete record, but you should be empowered to say, no, this particular record is sensitive, I don't want to give that information out.
Okay, thank you, Chris. Orla.
Louise, if you wanted to, I have the full things listed out. If you wanted me to read them, or I can tell you how to get that either way, if that would be easier for you.
It would be, yes.
Okay. can start with the top question that we've done, and then you can tell me who, you can point that to the person. Does the app have permissions in the same way as other smartphone apps require to enable location tracking? And that's from Joanna Goodman.
Yes.
So that's going to be Greg or Chris, I think.
Yeah, so on the Android platform, this is probably worth explaining. On the Android platform, the app does require location permission, and the reason for this is because when Google designed the APIs, as Chris was saying, they linked together location and Bluetooth, because Bluetooth does give a lot of information if you've got beacons in supermarkets and shops about where you are. There is no real technical reason this has to be the case. It was effectively a policy decision from them. The challenge, though, would be doing anything about it now. It's too late. You know, it's not feasible to update all these phones. Most Android phones only get updates for a couple of years. Majority of them are not going to get an update quickly, and it would take too long to get out there. But yes, there is a permission on it, and as Chris pointed out very well, that is a problem in that you can't just give one app access to Bluetooth.
Okay. All right, the next question actually is around when the app is technically going to be available, and will we be able to access the terms and conditions of that app before downloading it and activating it?
Yeah, so the terms and conditions of the app are available at the moment on I think if you search NHS COVID-19 app, you'll find them on part of the NHS website, and you can view all the details before you install it. You actually can find the app if you know what you're looking for, but there's no point in installing it yet because it's only designed to work in the Isle of Wight. It will actually work, just no one else will use it, so no point.
Could I ask a follow-up question, which is that we all know that when people are downloading apps and what have you, that they're not necessarily reading all of the terms and conditions, or if they are, they may not follow them. I think the best one is the Daily Mash, which just has whatever as its consent thing on it. If you've looked at those terms and conditions, and I must confess I haven't, how readily accessible are they in terms of understanding them?
Happy to look at them. It would be interesting to see anyone else's thoughts. They were relatively readable. The problem was that all the information spread across a whole host of web pages and Q&As and FAQs, which are clearly to try and avoid the big wall of text. But then there's a trade-off between either having a wall of text or having a whole host of Q&As that you need to set and go through, click, click, click. And certainly in the early days, there were some kind of contradictions between some of the bits, because clearly FAQs were getting updated as people were asking questions. So there were some points around, how long will data be stored for, or will it be used for other purposes, etc. And there were kind of confused or conflicted answers. I think some of those have been changed though.
Thank you.
I'm actually going to skip a question because it kind of follows on to what Craig was saying. Is there an estimated percentage of the population who need to download and use the app in order to make it effective? And that's from Sean Slade.
This is a good question actually. So there's a few different figures. You can work it out very easily. What you do is you take the percentage as a fraction and you square it, and that's the proportion of contacts you'll find. So if 50% of the population installs the app, then 0.5 squared is 0.25. You'll capture, on average, 25% of interactions. So generally, I think Oxford University believe roughly 60% adoption, which would be 36% of contact events. They feel that's when it could start to make a difference. I think the one thing that is worth just adding very quickly on that is there's a different use case to the app than there is to manual tracing. If you're on a train for half an hour in relative proximity to a few others, the traditional approach of, well, who did you meet? Oh, well, there was Steve on the train doesn't really work, because A, you don't know he's Steve because no one talks to anyone, and B, you don't know his phone number or his email address. So I think it's situations like that. If you do have more people using it, it can help. Nothing's going to be perfect because you'll never get 100% adoption. But I think if you do get close, if you get about 60%, you'll start to see potentially some significant impact. But nobody knows for sure. We just don't know.
Okay, this one's for Dr. Chris. You stated that the phone unique identifier lasts 24 hours. Thus, if you identify 48 hours later as COVID infected, how does anyone contact you have in your unique ID has gone if it's gone? How does that work?
So the underlying unique ID actually lasts the entire time you use the app. But what happens is each 24-hour period, it gets encrypted into a new random ID, which is not supposed to be linkable directly to you. So the central authority can see that ID throughout the entire 28 days, potentially recorded on someone else's phone. But the idea is that the period in which someone who's just observing the signals you're broadcasting, they would only be able to track you for that 24-hour period. Most other apps are starting to try and get that down to 15 minutes. Australia started at 2 hours, but is starting to modify that down to 7.5 minutes. And that's primarily about a privacy concern, because the longer you broadcast that same value, the longer the person can potentially track you.
And I think a follow on from that question from the same person, Duncan, Edie, was what exactly does the government hold on the person centrally from the app? Is it just the unique phone ID, location, date, and time?
So when you register, you don't really give particularly that much personal information. There's a small amount gathered in terms of a percentage of your kind of postcode, although the exact data that will be collected may vary when they finally roll the app out, because at the moment it's obviously limited to the Isle of Wight, so they need to try and check that people from the Isle of Wight are the only ones registering. In terms of the information that's collected in the broadcast, it contains your phone, make and model, the random ID that's been assigned to you, which shouldn't be linkable to your name. It will include the time and then all of those 8-second interaction measures as well. So you have a kind of, if you start your interaction at one point, then you will have the start time, the end time, the measure of the signal strength every 8 seconds, and that is all cut together into one single record of an interaction.
This one is asked to all the panel. With the goal of protect the NHS, save lives, if people fear to use the app or contact the government manually, what is the alternative? Continue to just walk around being infected, infecting others? What's the balance? I think, which was something that I was touching on. How do we find that balance? Anyone want to chime in on that?
Well, I mean, oh yeah, sorry.
Go on, Ola.
Sorry. Well, I mean, personally, in an ideal world, I think we would have a functional test, trace, isolate system plus an app. You know, I take the point that the app is not entirely substitutable for manual contact tracing. But at the moment, my major concern is that it looks like data governance is an absolute afterthought in both manual and the app in terms of contact tracing. So the impact assessment, which has to be completed by the NHS, is shoddy. It's full of holes. There are big questions that remain to be answered about who will ultimately get access to this data, how long will it be stored for, what uses will it be used for in the future. And it might seem like the data that is collected is quite remote from us as individuals, but the fact is that that data set can be linked with others, which can in itself be quite revealing. And I think there's been a bit of a sleight of hand here in terms of the way in which this has been presented to the public, because it's consistently described as anonymous and not using personal data, whereas from a legal perspective, it is absolutely personal data and not anonymous. And so, you know, I really just have concerns about the data governance issues there. And just to maybe highlight one fact, you know, we might be thinking of privacy in terms of who's following us, who's watching us, but I think we also have to think of data as a kind of a source of power that can be used to make decisions about us. Who gets benefits, who doesn't get benefits, what people's immigration status is, you know, a whole range of, you know, we know that the government currently aims to use more and more data-driven decision-making across various domains of policy. And, you know, the query is, can this data be used for those purposes at a later date? And we don't have a guarantee that it won't be. And so, you know, I don't think we can simply think of this as, you know, I've got nothing to hide, nothing to fear. This is about, you know, data as a way of controlling and making decisions about a population. And so I really think we have to get this right.
And well, I'm going to make a counterpoint here, is that at some point our focus on that it's not perfect and it's going to have problems, and here are the future things that can go wrong with it. If that's what the public is hearing, then even if it's not perfect, and even if they may not use the information incorrectly in the future, that by just giving the negatives of it, we're keeping people from using an app that may actually save lives. And so I think there's sometimes some anger from people who say, I get your concerns, but at what point do we say this is never going to be perfect, and the what's ifs and maybes of the future, yeah, maybe they'll misuse it in the future, but we can make sure that it's being used appropriately now and then keep an eye on it. But let's not scare people into thinking, oh, they may be doing it this way, they may do this with it in the future, which is in reality going to keep people from downloading it. We think a lot of people think like us, that we'll be willing to, we can make all of these decisions in our head. But I literally see people at the store who would very much like to be doing social distancing and standing in the lines correctly, but if those lines aren't on the floor, they can't judge for themselves what that 2 meters distance is. So until that's put down, they don't necessarily have the ability to even evaluate what 2 meters is. So if we're telling them, oh, this might not be safe, but we're doing it from an academic standpoint, we're scaring them into using something that may be very useful in helping reduce the spread of this virus. So where do we draw the line, and when do we start considering that we are having these, yes, academic thoughts about this, and we should be advocating that the government do a better job, but at what point do we also have a responsibility for making sure that something is done to protect health?
Can I just say, so
Sure.
Absolutely, but I don't think it's correct necessarily to think of this as purely academic. I mean, speak to the people in the US who are having their contact tracing apps used as a way to clamp down on a right to protest at the moment.
Yeah, that's
so well, okay, but I would kind of exercise caution. No, of course we've got different policy contexts, but okay, an example that's closer to home, whether or not we could contest the legality, but we know that in the most recent election, in the Brexit referendum, that we had data-driven political micro-targeting of individuals across the UK. That is openly acknowledged.
On all sides, and it's something that goes on all the time. Yeah.
Well, but the legality of the practices haven't been, of one side's practices haven't been condemned by the regulator in the area here. Whereas they have for one side of the campaign. So I'm not saying, I don't in any way think that it was data-driven targeting that kind of brought Brexit or other things. I think there are far more complex issue or underpinning reasons for that. But I'm saying that if that is kind of dystopia, then dystopia has happened already. So I think it's in some ways false to think that data won't be used in this way to change the way that to influence people in a way that is not visible to them, and to make decisions that affect their lives. So,
and again, I've done a lot of research on the issues of the data mining and Cambridge Analytica and all those things. So that is an entirely different topic we can go into, but that is also to me an example of the public not hearing one message and us understanding it a different way, and and saying that, oh, data-driven things meant that the election wasn't valid. That's what they hear and that's what they shout, when that is not what we're saying or what it actually is, or whether they did anything illegal, but that's what they hear. And so that's where I'm saying we need to be more careful in how we do these things.
Sure, and I think nuance is that, you don't want privacy to become, or the privacy call here to become the kind of new anti-vaxxer call. So I agree that you need some nuance, but at the same time, when you have the chair of the Joint Committee on Human Rights calling for legislation in this area, it's not simply a few kind of isolated advocates. It is a joint political, like a mixed political parliamentary committee, all party, from the House of Commons and the House of Lords, saying that they are not confident that the safeguards that have been put in place around the app satisfy legal requirements, and that they think that the app as currently formulated constitutes a breach of the right to privacy, then I don't think we can simply kind of dismiss that as the quest for perfection. Good enough would do. Taking data protection a little bit seriously would do for me. And I think we see unjustified statements in the manual contract tracing impact assessment saying 20 years. When the NHS has been asked, where did that 20-year figure come from? It is not in any way scientifically grounded. If somebody could point us to some scientific studies to say why you need to retain data for 20 years in order to tackle the current pandemic. But so I don't think we should also say public health, let's throw everything to the wall. So I don't think it's one corner or the other. So I agree. Maybe I've been kind of too impassioned, but I do feel strongly that we should be baking kind of good data governance in from the start.
I think my argument is that our passion for these things are not what is conveyed in the press as reality. So my concern is our ability to advocate on behalf of privacy on a public level is great, and we in our field, the legal field, the tech field, the academic field, should be pushing for it to be better, absolutely. But what I'm saying is how we're communicating that to the wider public is where it becomes problematic, because all they hear is the soundbite. Same with the Cambridge Analytica thing. They just hear the sound bites and they don't hear the rationale behind it. And so when they hear this is completely wrong and we shouldn't be using it, they don't hear that those it's been fixed so you can use it now is never heard. It's only now it's not safe, and in the future it won't be. I think we've probably beat that horse a bit, so let's go on to another.
I just want to add that Heather, I think your point is well taken, that you have a situation in which a media that seeks to sensationalize something, and when journalists who by the very nature of their craft are good generalists but non-experts, well, don't always, especially with this short news cycle we have and the fact that a lot of people now get their news via social media, don't have the time to do the research that we do to look into these issues. But I just would feel remiss if I didn't add that a lot of these concerns we're raising are not merely academic or hypothetical.
And I apologize for using that term.
As somebody who spent several years in Washington, D.C. working on privacy and national security issues, I had people in the Office of the Director of National Intelligence confirm that I met the criteria for a target of domestic surveillance, right? I was doing whistleblower stuff. Edward Snowden's father was a client. We worked with people like John Kiriakou and Thomas Drake. So I was surveilled. There's no question about it. Julian Assange would call my office. And so when you're somebody who's working as a legal advocate in this capacity, and you are concerned that the things that you're doing when you're speaking to clients is something that could be intercepted, and probably is, when you need to have an air-gapped computer so that you can do the work that you're doing, I would say that the idea that we should kind of maybe be measured with respect to how we talk about these things publicly is well taken. But I'd also point out that we had dragnet surveillance in the United States that was done in a secret fashion, authorized by a secret court. And there wasn't transparency and there wasn't accountability. And so when we hear things like the data is to be stored for 20 years, and let's just say that, fine, let's just stipulate that 20 years is what they need. What guarantees or sureties do we have that they're going to erase it after 20 years? So I think what's important is also to have an open audit process where there is transparency and there is accountability, because I think a lot of the privacy advocates would be better, kind of sleep better at night if we knew there was a way that we had some kind of private cause of action or suppression remedy or ability to make sure that the promises we're given are being adhered to.
Okay, so a powerful argument there that actually the government taking it seriously might increase the trust in the app and therefore make it more effective. Okay, thank you. Are there any more questions, Heather?
There are quite a few more questions. Let's see, is there an assumption that everyone has just one phone, always has it with them, always has it on with Bluetooth connected? I have more than one, so is that the assumption that there's just going to be one phone?
I think the assumption is more that people would only install it on one phone, but even if you had multiples, you would get alerted that you would get an alert that you'd been in contact with yourself, it would sort of resolve itself out. It would probably not be the end of the world if people had multiple phones. There is an expectation to leave Bluetooth on. The app will try and encourage them to do it. On iOS, if the app gets forced too far into the background, it shouldn't happen too often. It will re-notify and get the user to pop it back open again so that the app stays open. Okay. And that's all in the background. You don't see the app running or anything. It's just there in the background and doesn't use too much power.
Is that the same for either system, Greg, whether it's decentralized or centralized? That it needs to run all the time?
So,
some reference to battery power, battery usage being much higher with the centralized app because of its need to run all the time.
So this is an interesting one. There was there's a very interesting legal angle on this as well. Apple and Google came together and offered a kind of harmonized API and approach to use Bluetooth in the background, provided governments followed their guidelines and rules. And those rules basically said you must use a decentralized approach, you must use the data only for this, etc., and use the decentralized system we provide you. And they came together, put that proposal forward. Now, there are some technical limitations on iOS that make it very difficult to use Bluetooth in the background. And that's why this proposal came forward early on, because a lot of people were saying there's an opportunity here, but it's really annoying, it's problematic to use. Now, where this gets interesting is you've got two private companies basically laying down the law to governments, and that can become quite interesting as an area of legal analysis as to what right do they have and will they become the subject of an antitrust lawsuit in 2 weeks' time. So that's an interesting discussion there. But I think in terms of technology, there is a workaround to the iOS limitation, and that's what the NCSC implemented on the app here. And it's basically the apps keep each other awake, and they sort of ping pong each other. That's what that 8-second ping is doing, is it's making sure that the apps stay alive, stay awake, and the Bluetooth doesn't go to sleep. But in terms of power consumption, if you've got an Apple Watch or something, for example, that's using Bluetooth Low Energy as well, and it's, you don't see a huge significant deal. The app, it does use a little bit of power, but I wouldn't say it's particularly significant. I don't think the majority of people would notice it in their day-to-day use.
Yeah, I think we have
just to clarify one thing. The 8-second ping is to measure the interaction, so it's not about keeping it awake. That's one of the things we clarified with them, is this just a thing for keeping this thing awake, because you wouldn't need to do it every 8 seconds if it was. They're actually interested in the data that they can get from that 8-second ping.
Yeah, that's to get you a better, more precise resolution of back and forth, because as you move the phones very, very slightly, you'll get different latencies of the signal reaching them. But there is a separate ping pong keep alive. I think it's called heartbeat or keep alive, and that's used to keep the device awake if it is iOS and keep it active for Bluetooth.
Okay. I think we have two questions left that haven't already been answered. And one, you touched on it a little bit, which is, considering the legal challenges and privacy malpractice, does the panel see a likelihood of the app being challenged judicially? That's from Ishmael Hitar. And maybe Orla would be best to answer that one.
Yeah, I would say inevitably, unless there's a bit more clarity or there are more safeguards laid down in law. One thing that's interesting about and I've mentioned this, the digital app, is that it is reliant on consent as a legal basis. So this does kind of beg questions down the line about the extent to which you might be able to bring a challenge on the basis of the European Convention of Human Rights. And post-Brexit, that will be the only option in the UK to challenge the kind of rollout by the state of this type of infrastructure. So it's kind of interesting that if this infrastructure is rolled out and always based on consent, that the right to privacy kind of slips away. And historically in the UK, we have case law from the 1990s with the courts in the UK saying there is no right to respect for private life in the UK. It's not something that existed prior to kind of interaction with the European Court of Human Rights and the introduction of the Human Rights Act in 1998. So legally, there's no kind of long-standing tradition of privacy in the UK, as there might be, in the US through the Fourth Amendment, or in Ireland for, it's a constitutional right, or other EU states. So, that I think is a kind of a longer term risk. But in the shorter term, I would say an Article 8 challenge is possible. Yeah.
And I would just add that you say, as in the states, the state obviously being multi-jurisdictional because of this federalist system, we don't have the type of uniform privacy laws that you have here.
Yeah.
People seem to think that constitutionally covers this stuff, but it doesn't, including someone put a link in here that Minnesota's use of the contact tracing app is being used to check and find protesters. So that is very much, that's why I said US is a very different system. It has a very different level of laws around this, so it can't really be compared right now.
Well, I would just like to add, though, from the US perspective, and I know I'll keep myself short here, that there is something called the third-party doctrine, which states that information willingly shared with a third party loses all constitutional expectations of privacy. For those case law nerds like me, you'll look at this at US v. Miller 76, Smith v. Maryland 79, and expanded in cases like recently Jones and Carpenter. Well, not the third-party doctrine, expanded other stuff. In fact, there was a case in the middle of that, United States versus New York Telephone, which was the case at issue with respect to the FBI iPhone concern over the subject device possessed by the San Bernardino shooter. But going back to this issue of the third-party doctrine, the case law is split about what constitutes willingly shared information. There are some interesting cases out in the Northern District of California that distinguish between a cell phone pinging off towers randomly and people actively using a cell phone after being suspected of committing a crime. So when they're actively using the cell phone, the case law seems to indicate that as an active sharing with a third party. When they're not using the cell phone, it's kind of pinging passively. That's a thing, that is an issue. So the other legislation that would come into play would be the Electronic Communications Privacy Act and the Stored Communications Act, and potentially, depending on what's being done and how it's transmitted, the Wiretap Act. So yeah, but these are at a federal level, and as Heather said, on a state level, there are other issues involved here. So it's a very, very complicated system. Going to the consent issue that Orla's brought up earlier, in the states, if you consent to use the app and download it, then that could be seen as a willing disclosure, and the third-party doctrine would come into play.
Yep. And there's a fun last question for all of us. It's a poll, actually. And it is yes or no, are you going to use the app?
I guess I'll start by saying I will use it on one of my devices if it comes to my jurisdiction.
I'm the same. I will use it on one of my devices.
Looking up Chris's point earlier, is that the device that you don't use when you go to visit your lawyer? I think you suggested that might be the sensitive point.
Not the one I do my banking on. Definitely not that one.
Yeah, I mean, I don't know. I've got a very vulnerable family member, so you know, I have a very strong incentive to use the app. I don't necessarily see it about whether or not I would use it though, because my immigration status is at the moment relatively certain. I feel like I'm fairly confident my employer isn't going to, compel me to produce it in the morning. So every morning before I go to work. So I think it's about ensuring that those who might be vulnerable as a result of the rollout of this app are kind of protected before it's used.
Yep. Craig?
Yeah. Probably, yeah. I don't think there's any particular reason. I've actually got it on phones from reversing it and stuff, and I'm not unduly concerned by anything that's on the app. One thing I think that was interesting, I saw some data the other day that did suggest that people are more likely to trust a contact tracing app that is centralized rather than decentralized, based on some research. That was quite interesting, and I think it comes down a lot to public perceptions and people's willingness to trust people versus tech, and I think that was quite interesting to see.
Yeah.
I think I want to see the issues we raised fixed first, because they were technical issues that should have been fixed certainly before rollout. I'd have to review the kind of policy point, because at the moment there's easy wins in which they could gain my trust if they ring fence the data, and there's no reason not to do that, which makes me suspicious of the reason to not do it, because there would be no harm in the utility of that data if they ring fenced it only for this purpose. So I don't understand why they wouldn't just put that ring fence in. If Australia can be ahead of you in privacy legislation, that's normally a bad sign that you're some way back, because they're not known for having the best privacy act, and they've done that. So there's no reason that we shouldn't be doing that. So I want to see that first.
And our chair?
I'm undecided actually at the moment. I agree with Chris that and all of that there are issues that ought to be relatively simple for them to resolve, and I'm concerned at the fact that they haven't. I'm also in a minority on this panel because I only have one phone, and therefore once I've downloaded it, all I can do is forget my phone to whenever I go to see my lawyer. So yeah, I'm undecided at the moment, and I would hope to see them rectify some of the, I think, relatively easily rectifiable issues that there are. I don't think I have an enormous problem with the centralised versus decentralised, because I can see there are pros and cons to each, but I think that the compliance with data protection principles is important.
I think we were just asking for clarity. I think if I counted that right, we have 4 yes, even if tentative, we would use the app. 1, if they fix the thing, the ring fencing particularly, they will use the app, and 1, I'm on the fence. So it's about a 4 to 2 ish. Does that seem right? Did I count that right? Yeah.
Are we assuming you're a yes, Heather?
Yeah.
Mark?
Oh no, I was raising my hand indicating that I had a yes, that I would download it on one device. So maybe count me as half.
One device, that's all I need.
I'm going to have to get myself another phone, I can see.
Okay, back to you, our chair.
Yeah, well, yes. Thank you very much indeed, everybody. I think that's been a really, really interesting discussion. Absolutely fascinating to have so many different viewpoints. So thank you again to Matt and Gareth, who I think put the panel together and managed to get a really good sweep, a good debate, difference of opinion on some of the issues, which always makes these things better, I think. So thank you very much. Do keep posted on what is happening next. There are plans for further events to be held between the Sheffield legal hackers and the London legal hackers, and maybe some legal hackers from elsewhere. Maybe we can get Washington involved, or someone else instead on the basis of some of our panel tonight. But I think food for thought. We ought really to have done an audience poll as well, shouldn't we, Heather, to see what views people had at the end of this. But maybe we'll next time we'll do that. Next time we'll do an audience poll. So it just remains for me to thank the legal hackers, to thank Heather and Anson Evaluate for supporting this event, and to thank all of our panelists for sharing all of your expertise, for putting it in a way that for the non-techies or the non-lawyers amongst us was very accessible and understandable. And so for that we are truly grateful. So thank you again.